Institute for Tele-Information, professor at Columbia. I'd like to welcome you from New York. Beautiful weather today. That's ha. And you're here joining from all over the world. We're very grateful. We're grateful to the panelists. We're grateful to Bill Drake for organizing this panel and this discussion series. So today's topic, as you know, that's why you're joining, is about the UN draft treaty, a convention that is being discussed and possibly finalized these days about cybercrime. It's been controversial, although it's been somewhat, at least outside of the expert community.
It's good. Well, no, it's good.
Under the radar. Please mute yourself, everybody. Thank you. So now it's controversial, but it has been passed, the earlier draft, 79 countries for it, which is not a small number. Now, the panel that I see here in the discussion of experts in the United States seems to be fairly critical of this draft. And I join that criticism. However, if 79 countries are of the opinion that it is good for them, one has to give this some fair hearing and hear them out, even disagreeing, even refuting, but certainly listening. And that's important. The panel today might be more critical than supportive, so I would like to raise at least several questions to answer, and really briefly. The first one is, or points to make. The first one is, in any treaty negotiations, one gives and one receives. It's a give and take, and so it's in some sense easy then to jump on the points that one has conceded, even if they are painful, without recognizing what one has received. So it is important to understand what would countries like the US, other developed countries, what would they gain from that treaty also on the positive side. The second point is, I think we all agreed that there's a crime problem and that there's a cybercrime problem. And so in some ways, one also has to ask the question, what can one, in a form of a treaty, do in order to deal with that? Now, crime is an issue that is defined in every country, in every society quite differently. It is based on social conventions, on culture, on history, on all kinds of political priorities. So there's no way to define crime, and therefore also cybercrime, in a globally unified way. And so if you have a treaty here, and that gets me to the third point, which is national sovereignty. In a way, the world system works that countries, sovereign countries, can make decisions for themselves, and certainly about crime, which is a central issue. Whether they are smart or not is, on some level, their business. Whether you have a death penalty or not, or stuff like that, is not necessarily one of an international agreement. And the United States would never agree to a crime definition, and therefore also cybercrime definition, that is the same with, say, Iran or Saudi Arabia or Russia or whatever. So we, US too, would want to protect our sovereignty, and therefore one has to concede the same rights to countries that are more authoritarian in nature, such as China and Russia, as much as we possibly dislike the outcome. And so those are some points that I think I would like to see addressed and discussed, rather than only focusing on what's wrong with the treaty. So with these words, I'd like to thank Bill for organizing this, and he can take over and moderate.
Okay, thank you, Ellie. Those are very interesting observations, and I think ones that we will try to make sure that we bring to the fore in the course of our dialogue here today. So welcome, everybody. And this is, as always, the monthly Global Digital Governance webinar of Columbia Institute for Tele-Information, which Ellie's director. And we meet every month during the academic year to cover a range of topics, and many of you have attended previously. You may know that videos and transcripts of our prior events are available on the website of our series. So for today's topic, you know, for those of us who work in the realms of telecommunications and internet governance, there's an enormous range of issues that are being negotiated or fought over at any given time that all together sort of collectively make up this incredible tapestry of governance mechanisms of different scope, scale, strength, and so on that shape the digital order internationally, or at least help to do so. Cybercrime is one that I think my sense is a lot of people who are working more in the telecom internet world don't track as closely. And yet it is hugely important, and it is being conducted among specialists, just like all of our other sub areas, by a lot of people who are legal scholars and experts who engage very deeply in a variety of different processes. And this work has been playing out over the past 25 years at a variety of different multiple levels and among governments in different types of groupings with work on cybercrime, mutual law enforcement, and so on. At the broad multilateral level, the most important result of these efforts to date, of course, has been the Budapest Convention on Crime, cybercrime negotiated in the Council of Europe in 2001. They also had additional protocols in 2003 and 2022. The Budapest system sets out a binding treaty that addresses cybercrime and enables procedural powers. It promotes international cooperation on mutual legal assistance and a number of different key issues, and really focus a lot on sort of core cybercrime, what most people would think of as cybercrime, stuff that's actually attacking connected systems or networks, or using those systems frontally to do so. And also covers computer-related crime like fraud, things like that, and some content-related stuff, child pornography, intellectual property, with an optional bit on hate speech, because not everybody can agree on that. It is not an unproblematic framework, but it's the best we have out there today. And the convention was done with explicitly global ambition. Not only were the Council of Europe's 46 members participants, but so was the United States, Canada, Japan, many others. There's now 68 parties from around the world, and 15 more have signed on to exceed. So you think we have a system that we're already building. Nevertheless, Russia, China, allies of theirs and others have long refused to join in which they would have a more direct hand in shaping things. And not surprisingly, Russia has been looking for many efforts around internet issues to leverage the mechanisms of the United Nations and the rules and procedures to its advantage. And so you are probably aware that in the parallel world of cybersecurity, Russia in 1998 called for a UN framework on interstate cyber conflict, and in 2011 put out a big proposal with China, Tajikistan, and Uzbekistan, calling for cooperation against dissemination of information that some states might believe incites terrorism, secessionism, or extremism, which really harkens back to the Carlsbad decrees of 1819, when the German Confederation was trying to suppress speech. They also asked for language that would prevent actions that would undermine other countries' political, economic, and social stability, as well as their spiritual and cultural environments, which is pretty broad, and that the UN should help to protect states' sovereign information spaces, which became sort of the beginning of their long-running argument that there's something called the national internet segment, which could be subject completely to their digital sovereignty, and the UN should do it. So the cybercrime stuff has to be viewed in the context of this larger effort on the part of Russia, China, and others to leverage the UN mechanisms for their aims. In December 2019, the UN General Assembly approved on a rather divided 79-60 vote, as Ali mentioned, with 33 abstentions, a Russian-driven resolution calling for the negotiation of an international convention on cybercrime. It was backed by China, Iran, many other like-minded countries, and it led to the creation of the ad hoc committee, the HC, which held 6 sessions in New York and Vienna in 2022 and 2023, And the process has now reached a turning point with a so-called concluding session. We'll see if there's more being held next week, January 29 to February 9, here in New York. So people will be coming into New York who follow these issues to keep a handle on these negotiations, which will present a lot of hard choices for Democrats and others who might desire to have good UN framework for dealing with cybercrime where it could be useful, perhaps something akin to the Budapest Convention. But the direction of movement so far seems to be different. There are a lot of ideas that have been put on the table by various parties throughout this process, and some of which may come back again, that are highly problematic. And the draft text that is the baseline for this negotiation looks difficult. So there are a lot of issues in play. We're going to talk about them today. And to do that, we have an excellent panel of experts and analysts and participants who have been involved in these issues. Nick Ashton-Hart, who you see there, is the Senior Director for Digital Economy Policy at APCO Worldwide. Nick participates in the UN Cybercrime Convention Negotiations as the head of delegation for the Cybersecurity Tech Accord, which is a coalition of 150 private sector companies that are involved in the digital environment. Nick also participates in other international organization processes, including as a member of the UK delegation to the ITU, and he's very involved in WTO stuff in Geneva. Katitza Rodriguez, has she arrived yet? Have we seen Katitza? Somehow it seems that we have not got Katitza yet, but I've pinged her and I'm hoping she's going to show. Has been the Global Privacy Policy Director of the Electronic Frontier Foundation since April 2010. In 2018, CNET named her one of the 20 most influential Latinos in tech. Previously, she directed the International Privacy Program at the Electronic Privacy Information Center, and she participates as well in the HC process as part of the Civil Society Coalition. Finally, for a broader analytical orientation, we have Tatiana Tropina, who is an assistant professor in cybersecurity governance at the Institute of Security and Global Affairs at Leiden University in the Netherlands. She is the co-chair of the Freedom Online Coalition Advisory Network and has held previously various leadership positions in the ICANN community. And she was also a senior researcher at the Max Planck Institute for Foreign and International Crime Law. So that's our group, that's our topic area. And the mechanics will be, as always, that we will do 3 to 4 rounds of questions through the tab among the panelists to try to elicit some of the main points. These will be points that we've talked about in advance as a baseline to organize the conversation. And then, as always, at the top of the hour, we will move to open discussion among all participants. I see 61 people online here with us. So I'm hoping, including many familiar faces and people who know this stuff. So I'm hoping that we can have a very good and robust conversation once we get to that stage. So that's the plan. So let's begin. Let's start from the top, I suppose, with the substantive issues. What's in the current draft document that will serve as the starting point for next week's meeting at the AHS? What do we anticipate in terms of previously problematic proposals that may resurface or other new kinds of things that states may try to put on the table? Why don't we try and talk through some of the broad substantive stuff first? Later, we'll go to sort of the political alignments and so on. Let's start with, for example, questions of definition and scope. This is key to any one of these kind of topic areas. How you define cybercrime, terrorism, extremism, disinformation, et cetera. These are all difficult issues. And the scope of the document seems to go well beyond cybercrime itself. So these are kind of interesting baseline issues that I think we should take up. Why don't we just go in alphabetical order? So Nick, why don't I start with you, and then we'll go to Tatiana. I'll look for Katitza. Go ahead.
Thanks very much, Bill. It's a pleasure to be asked, and I'm glad there's so much interest here, including my very good friend Cheryl Langdon. Oh, it's 3 a.m. in Australia, and she's dialed up. I salute you. That is one of the biggest problems with this convention. Is as you alluded to, the countries who are participating in it do not have a shared objective. They have very different and somewhat conflicted objectives. And so while parts of the treaties say that this is only about cybercrime, it's not defined. It wasn't in Budapest either. A group of other states, Russia in particular, would like the convention to apply to any crime, whether it is in the treaty or not, as long as a ICT was involved in the commission in any way. So simply using a mobile phone as part of a otherwise entirely real-world kinetic crime would qualify for international cooperation under this convention. There is, of course, an argument about the core conventions everyone does agree should be in, the core crimes are those in Budapest, though they have broadened the scope of some of them in nonsensical ways. For example, the crime of fraud, which we've argued you don't really need to criminalize fraud. Everywhere in the world, fraud is a criminal offense. The Chinese delegation would like the fraud article to be expanded so that any person who through deception induces another person to do something or not to do something that they would either do or not do is guilty of fraud. So basically, you can make anything. As long as you were deceiving and deception is not defined, that would apply to anything. This is just one example of how this really isn't a cybercrime convention for a significant number of delegations. They just want a crime convention with greatly expanded powers and with far less safeguards than they would have if they joined Budapest. And on the other side, you have Budapest countries who don't want to see anything broader than Budapest in most cases, but are unfortunately willing to go along with broadened scope because they're copying and pasting of provisions, which is another of the big sort of cognitive dissonances here. Is there's this notion, especially amongst Budapest countries, that if they simply copy and paste many Budapest provisions, they will have the same effect amongst 194 UN member states as they have amongst Budapest's parties. However, Budapest, when it was adopted with a 60-page explanatory report, which specifies the rule of law-based environment that we would recognize in democratic states as being the foundation, and then you apply Budapest provisions on top of that. And to join Budapest, you have to actually justify to the other parties how you have in fact implemented the convention's provisions in accordance with the provisions, the elements of the explanatory report. In addition to that, Budapest's Secretariat publishes regular analyses of the implementations of the convention by the parties. It's like a report card. And that includes how the provisions are implemented in congruence with the explanatory report's requirements. That's also missing here. So it doesn't make sense to argue that you will get the same result from selective copying and pasting absent those two conditions. And civil society and industry have been very vociferous in saying, we don't accept this as this logic. We don't accept this as reasonable. The major issue here is, well, there's several, but one of the fundamental problems is copying and pasting Budapest without any of the time limits in Budapest. So you can access data under various conditions in Budapest, but there are time limits, 90 days, 180 days. This treaty has gotten rid of all of them. So you can have the data and you can keep it for as long as you want. There is a data protection article which subscribes how you can use it to some extent. But basically what you have is a system where the governments worldwide can pass around the personal information of individuals entirely in secret, perpetually in secret. And this is not congruent with the rule of law for a start, or data protection legislation in most of the world. But we would also argue that it's not congruent with the UN Charter. This is not, this is something totalitarian states might agree amongst themselves, perpetually secret actions. But it's not something that the democratic world should, on a principled level, endorse irrespective of the venue. And this is one of the biggest problems with this convention, is many democratic states, because it is their justice ministries who are leading on the content, are willing to allow allow things to go forward that you would just never, like, in no other area of domain of international relations is the West currently in the business of allowing Russia any diplomatic victories, let alone giving them something that they want, whatever it is. And in this convention, they're proposing to give Russia and China this sort of perpetual access system. And because it allows any two states who agree that something is a crime to cooperate on it. And so it's not about cybercrime, and therefore it allows any two states to say, well, you have a citizen in your state that is criticizing my government, so I want you to turn over information about them, and them. There's also extradition in this treaty, and actually turn over them too, so that I can prosecute them for this in my state. And because there is no ability of a service provider to say no to any request for data access under any conditions, Western companies, well, global companies, would be in a position of having to collude with what is self-evidently not a crime in the jurisdictions in which they are headquartered or operate. In fact, participating in helping these countries might itself be criminal. With no ability to say no, and because it's all a secret, no one gets to know about these abuses that are going on, and so it's particularly astonishing to me that the Western states aren't saying, "Look, I'm sorry, it's complicated, but in 2024 we can't have a secret data access regime globally that's permanently secret. We're not in a position to." We don't work that way. I brought this up with Western states and said, this is illegal. Like, doing this in your country would be an illegal act. Like, you don't do this. You have warrants that expire. People are allowed to be notified when their data is used if it's no longer important to a prosecution or an investigation. So why aren't you even willing to stand up and say, look, we're not prepared to agree to this in the UN because it would be illegal for us to behave this way. And while the convention doesn't force us to behave illegally, we don't believe in endorsing illegal behavior globally through a UN legal instrument. And because we have, unfortunately, as I said, so many justice ministries are in the lead, they are being silent on this question, with a few exceptions. Canada is very vocal in saying no to all this, that it's wrong, that it's not congruent with Western values, and certainly not with Canadian values, and that they won't be a party to it. But you would think that this is something where the EU, which is very vocal about the protection of human rights internationally, would be on this like a rash, and they're completely silent about it, basically. So hopefully that's helpful and not too long.
Yes, no, it's very helpful, but a lot of it bleeds into the next set of questions about what the players are doing and so on. I want to say closer to the fundamental question of scope and definitions. The baseline for trying to do this are, so people understand exactly what is being proposed here in terms of the reach of this thing and the foundations upon which it would stand. Katitza, you're with us now. Fantastic. Would you like to go next, or shall I go to Tatiana? You have to unmute.
I think I just arrived, so better Tatiana, and then I see where we are in the discussion.
Okay,
I can jump.
great. Let's go, Tatiana. Go ahead.
Thank you, Katitza. And okay, so just about the scope. I just want everybody to understand when we say scope or substance, it's a bit different when it comes to a criminal justice treaty. The scope in what has been proposed has three layers or three tiers, if I may. One of them is the scope of what we consider crime, right? What is criminalized? And it blends into answering Ellie's question in a more general, more specific way. Of course, a big criminal justice treaty cannot, approximate what states can or cannot consider crime. Of course, they're sovereign states. But I would respectively disagree that states are absolutely free to decide what they consider crime, whom they are going to cut head or hand. There are international human rights obligations that serve a benchmark. Of course, states do not follow them, but there are some benchmarks, there are some limitations, at least formally. Now, when it comes to the UN Cybercrime Treaty, if we look at the process and trace this process, at the beginning, the consolidated negotiating document contained all the laundry list of crimes that countries wanted to be in this convention, including extremism, terrorism, and, by the way, all other illegal acts that country might consider illegal, right? So imagine this criminal law Christmas tree with all the good, bad, and the ugly. Of course, this could not go till the final stage. Right now, we have a draft that resembles in its scope of what is crime, the Budapest Convention, except some of the very weird things, like Nick said, like this fraud by omission to do something, which was apparently proposed by Chinese delegation, and which can be interpreted super, super wide. We also have some crimes like intimate image sharing without consent, and we actually have a catch-all provision. There is the Article 17, which said that any crime in the international treaty we've committed with the ICTs should also be the subject of these, all the measures and whatever. Which is a catch-all provision because there is no specification. So basically, yes, terrorism, extremism, drug trafficking, and whatever for now are absent. But there is the catch-all provision which can potentially get the scope of what is crime to an unimaginable extent. This is the first thing. So what is crime? A note, however, a caveat. I have seen a very relentless push throughout these negotiations to add everything back. Like, for example, in the 6th substantive meeting, Russia and some others tried to push again to add terrorism, extremism, coercion to suicide, involvement of minor in commission of illegal acts, or whatever is on their wish list. So I would not exclude the possibility that at the concluding round, this relentless push is going to be back. So this is the first pillar of the scope. The second pillar of the scope, and this is where, forget about cybercrime. This treaty is not about cybercrime anymore. It's about any crime that leaves digital traces. We are talking about procedural power. What kind of powers states can use to collect and access data in criminal investigations? And there is no limitation on this so far as I see. And Katitza, I hope that you do not mind if I leave it to you, because I don't want to speak for too long and you are the expert on this. So this is the second part of the scope issue. And this is not substantive scopes. This is the procedural scope. And now, even more dangerous thing, and this speaks to what Nick said about mutual legal assistance and states being able to cooperate. So what happens with the mutual legal assistance? The draft, the current draft, tries to limit scope of data exchange in criminal investigations to the so-called serious crimes. What they did, they tried to limit, yeah, fair enough. They took the definition of serious crimes from the UN Transnational Organized Crime Convention, fair enough. It's the crime which is punished with at least 4 years of imprisonment, fair enough. The problem is that this limitation in this definition in the Transnational Organized Crime Convention exists only in the context of organized crime groups. So they basically took this definition in the face value, transposed it to the draft, wonderful, without any other limitations. And now imagine, in terms of scope, many countries criminalized fake news, political speech, extremism, and whatever, critique of the government. And these criminalizations would easily meet the threshold of serious crimes because many of them punished with 7, 8, whatever years of imprisonment. And these countries can legitimately cooperate using this convention. And this is what Nick was telling. And this is incredible, because you know what? This is not cybercrime treaty. This is a criminal justice treaty. And if the scope is that broad and undefined, with a relentless push to get it even broader, basically it's a treaty which says a country is free to define a crime and free to use whatever powers to collect evidence for any crime. And by the way, we're legitimizing cooperation on any crimes that you consider serious. What it has to do with cybercrime? My answer is nothing, except some crimes, which are pertaining to computers and computer systems. And this is something that cannot easily be undone. And coming to Ellie's last question, sorry for talking long. Ellie, you said that in the negotiations, one gives and one receives, and this is give and take. I would say this is a very ill-defined consensus, ill-defined consensus for the purpose of this treaty. There is no give and take when it comes to human rights and violations. There is no give and take. There is no compromise on this. There should be none. Thank you.
Thank you, Tatiana. That was well said and very concise. Okay, Katitza, now you're settled in. What more can you add to this? We're talking about sort of the foundational issues around how the core terms are defined and the scope of the agreement, what they're trying to get in there or not. Listening to Tatiana and reading all the stuff, it's starting to sound like, to me, this agreement covers any crime involving a person who has a crime involving. Hopefully it's more bounded than that, but exactly how, I'm not sure. So Katitza, what are your thoughts?
Okay, I think that Tatiana at least has talked that there are problems with the scope of the treaty, and there are 3 layers. She focused her speech on the chapter on criminalization, and I'm going to focus on the 2 other chapters: the one on domestic criminal procedural measures and the one on international cooperation. So both have a very broad scope. It's the domestic powers to access evidence and to investigate someone could be used for any type of crime when it comes to domestic criminal procedural measures. This means that it could be crimes that are even inherently in violation or contradict international human rights law. When it comes to international cooperation, one country can aid another states on using some of their surveillance powers, those that are stated in the criminal procedural measures, for the investigations to access evidence to investigate crimes that are serious crimes with a minimal threshold of 4 years, and no other limitation. The problem that we have here, because when you say serious crime, you think, oh, this is really problematic, a serious crime. But the problem that in many countries, just raising the rainbow flag or just being yourself, LGBTQ plus, means death penalty. Is a very serious crime in many countries. What is happening is that the UN is providing a legal basis for authoritarian regimes to use the treaty to cooperate for the access evidence for these purposes. So because many of these crimes that are inherently in violation of human rights law will be kind of authorized, this international cooperation, this kind of accessing evidence. You will say, I'm sorry. I'm sorry, I have a problem here. So one of the things that is happening is that one of the things that is happening is that you will say, well, it's serious crime, yeah, but these authoritarian regimes will already cooperate between themselves. Well, that could be true, but you're providing the legal basis under the UN umbrella to legitimize this type of cooperation. And that's not acceptable, especially it shouldn't come from countries with democratic values. So this is like too broad of a scope, and it just incorporates. One of the designs, just go back, one of the designed features of this treaty is that it defers all to national law. So in the scope, is defined to notion. It let countries define what are crimes, and then the treaty allows the cooperation according to those crimes as defined by national law, and that's a big problem. The other problem that we have, and just beyond the scope, so that's one of the big things: the scope on domestic powers, any crime, and international cooperation. Any serious crime with a penalty of 3 or 4 years, depending on last 4 years. And one of these features is because the design of the treaty is to defer to national law. The second problem that we have is the safeguards. So, well, we have a language that is very weak, especially taking into account all the development that has happened when it comes to government access to data. But these safeguards are in Article 24, which is the article of domestic criminal procedural measures, only on the domestic surveillance powers. But this article is not applicable to the international cooperation. Why? Because the state has decided to defer to national law. And that will work for some countries like the United States or some democratic countries who have, a strong safeguards in place. But that's not the case for other countries. So there will be a disparity between this, when a country can disclose the data to a third country. The rule says in the treaty is that a country can disclose the country disclosing the standard for accessing the data will be the standard of the country disclosing the data. So if the data is the country is the United States, maybe it will be a good standard. But if another country, it won't be the same. So we are asking for minimum standards in the treaty. So at least you can level the playing field when it comes to access to data. When it comes to the basic safeguard that we have always talked, like legitimate aim, necessary, necessity, proportionality. Even the principle of necessity is not in the treaty. Transparency, notification, judicial oversight, and in some cases, prior judicial authorization when it comes to very, very serious invasive surveillance powers. So we have two problems with safeguards. One, that Article 24 is not robust enough, but 24 only applied to the domestic surveillance powers. And two, that article on safeguards is not applicable to the international cooperation. The other big problem that we have is on data protection. So the article allows for the sharing of personal data in many cases without safeguards for law enforcement cooperation, and it's very broad kind of cooperation. It could include personal data. They say data, but it could include personal data, even biometric data. But the treaty doesn't have minimum safeguards in the treaty to regulate this sharing of data among law enforcement. And so this is really problematic because, again, it defers to national law. And that's one of the big issues for us, that many countries, it's just there's different protections among countries and there's no harmonization even to the minimum, and that's really concerning. I think I will stop here and will defer to others to
Thank you. That's very helpful. And I think the core point in a way that you're bringing out, this is inherent in these kinds of agreements, is that when the terms are not precisely bounded and clarified, and you basically create a mechanism to tackle a problem where you leave it up to the interpretation of each national country to then decide exactly what fits the term, you end up with a mandate, that gives broad legitimation and permissive international legal permission to more problematic countries to interpret the terms widely, to weaponize mechanisms to go after their opponents and things like that, which seems highly problematic. And this is true not just of treaty frameworks like this, it's true of guidelines, it's true of a lot of the different types of instruments that are being attempted in intergovernmental settings. When you try to have a coherent set of rules for such a disparate, geopolitically divided global polity, you end up with some Can we talk a little bit more precisely though about some of the kind of speech acts and behaviors that are being addressed by this framework? As I read some of the texts, some of the proposals that have been put forward, I see language that's pertaining to disinformation, pertaining to incitement, all kinds of things where I think, are these provisions being consistent with international human rights law? First of all, are they attentive to what the existing global frameworks are or not? I mean, what kind of speech activity, what kind of behavior would be potentially more regulated if you implement something like the existing document? And Nick, do you want to start us? Nick?
Yes. I mean, this is one of the key questions. And the answer is, as you've just heard, because it's possible for any two states to cooperate on any crime that they...
You froze.
...both recognize. Am I still frozen?
You're okay now. It's just kind of a little bit
weird. Yeah, this is one of the key problems, is because any two states can define what a crime is between themselves and cooperate on it, or any 2 or 3 or 4 states. This is a totalitarian state's dream, because they and their friends can team up on anything that they want and call it a crime, jointly investigate it, require any provider from anywhere in the world to give them the data that they want, and the whole thing is a secret. So this is ideal. It's the old thing of, what will you do? What do people do if you turn off all the lights? And we know the answer. They do things that they wouldn't do with the lights on. And this is what we're proposing here, is let's allow any state to cooperate on any act they want with anyone else and keep it a secret. And thanks to new provisions that have just been added, you could have said at one point, well, a lot of this data is in Western hands. It's in the US, it's in the EU, Ireland, whatever. So most of the data that countries want, they're going to have to go to one of these states, and they're going to say no to the worst abuses, because those states will not recognize many of these speech-related offenses as a crime, so they won't cooperate on them. Unfortunately, the latest draft introduces a new provision which would allow any state to go to any other state that's a party of the convention and demand and ask it to force service providers who have an office there to give them access to any data of that providers anywhere in the world. So, like, no one would go to Europe for data anymore. Why would you go ask Europe for European data if you can go to a tiny African state or a tiny Latin American state? And because there's a sales office of the multinational firm who has that data in the EU, in that country, they can demand the data from the sales office. And there's no ability of that sales office to say no, even if they say, well, we're a sales office, we don't have any legal ability to access this data. The convention is blind to that. The mere fact that it's the same company, the same legal entity that owns it, means anywhere in the world the data would have to be turned over. So then you lose all protections that you might otherwise have if the data is held in a jurisdiction which has high, relatively high treatment of human rights and many data protections. You wouldn't go to any of those jurisdictions anymore. You go to the sales office in a tiny state and demand the data that you want. So there's literally then no barrier left anymore, and no jurisdiction is safe any longer, and no firm is really safe. If you open an office anywhere, you don't agree to go along with this, but your local staff will be arrested. They're a crime. They're actually criminals for not colluding in abusing the rights of others, and that. Like, there shouldn't be any treaties that facilitate that, and they certainly shouldn't have the UN's name on them.
That is amazing. And that aspect of how it impacts companies, providers who hold so much of our information and transfer it, I think is an important point that really has to come out. It's not just a direct, the question on civil liberties and human rights of individual users is one thing, but the constraints imposed on the private sector, on organizations to comply with these laws strikes me as pretty onerous. Tatiana, do you want to add on?
Yeah, absolutely. And I also want to say, in addition to what Nick said, we already have examples how authoritarian countries basically took staff of communication providers and digital platforms hostages. We know all this. We have these examples. They are very well documented. And why negotiators somehow close their eyes on this, like what kind of impact this would have on providers, is beyond me. But okay, you asked the question about criminalization of speech. I think Nick covered it pretty well in terms of international cooperation. I just want to say that there is, I'm going back to my favorite horse, my favorite pony, the criminal law and scope of criminalization. There is a lot of optimism that this bill, what you saw was probably consolidated negotiating document, and indeed it had disinformation, fake news article proposed by China, extremism, terrorism crimes proposed by Russia, and what have you, or at the latest version of the draft after the 6th round. The new draft looks, I'm highlighting this word, looks cleaner. Because there is no terrorism provision, there is no extremist provision, there is no nothing. There is certain types of content which is criminalized is child abuse material, which is probably something obvious. Well, countries can agree on this. There are some problems with this criminalization. The current criminalization basically punishes adolescents for sharing self-generated material. But this is probably solvable. Another type of content that is criminalized, it's not a content itself, but non-consensual content, when the intimate images are shared without consent. It's also problematic criminalization, but that aside, it's not really speech or expression criminalization. With speech or expression, somehow people are optimistic that if there is no extremism or terrorism crime in this draft, then it's all good. Well, my answer is it's not. And I'm coming back to the point about Article 17 that allows countries to, rather obliges countries to criminalize anything that is in the international treaty, which is committed to the use of the ICTs. And we have to understand that it's not only about International Criminal Justice Treaty. ICCPR, International Covenant of Civil and Political Rights, is also an international treaty. And if you look at the Article 20, it says that propaganda of war should be prohibited by law. Hate speech, certain types of hate speech and discrimination should be prohibited by law. This is so much open to interpretation. And many countries would say that their prohibition of extremism, authoritarian countries, is of course against hate speech and discrimination and what have you. It's all about balancing acts. And this article, which is a catch-all provision, would allow to criminalize various types of speech. So while we don't see speech directly prohibited in criminalization, when we look layer after layer, there is a catch-all article which would allow countries a lot of loopholes to do whatever they want. And then, as Nick said, there is not even a loophole or open door. Come and get it. Allowing countries to prohibit whatever they want and cooperate on this by virtue of the United Nations Convention.
Okay. Thank you. Katitza, we need to move a little bit more concisely. I want to get at least one more round of questions in before we go to the open discussion at the top of the hour. But Katitza, just briefly on this point.
Yeah, I wanted to react to one of the questions in the chat, which is relevant. It's about the GDPR, whether the EU will undermine or not the GDPR. Well, in the EU, you have both the GDPR and the police directive when it comes to access of personal data. But the way the treaty is designed is that it will defer to national law, meaning the data sharing for law enforcement cooperation will be held according to the data protection law of the EU. In that way, it won't undermine the EU, at least within the European Union. The problem is that it will, anyway, undermine the cooperation with other countries outside the EU, because there is no minimum data protection standards and the police directive is not everywhere. So that's something, it's not like a global treaty, and the global treaty on data protection, which is Convention 108, is not being ratified by all the authoritarian regimes. So that's one of the big problems that we have. Just wanted to react to that. And finally, there is one thing here. This design to defer to national law is not only for this treaty. We have it also in the Budapest Convention. It's the way it has been designed. And we have seen from the implementation and analysis of domestic laws that when countries implement the treaty, they don't implement, for instance, the general articles of the safeguards. And the safeguards defer to national law, but it's not robust. You don't see in a comparative analysis of legislations robust safeguards across the world. Even the factual basis for accessing the data is not like a basic requirement in many countries in Latin America. And many countries may be in this model where transparency is not a default. And some notification to users and even the statistics about government access requests is not like the common ground. And so we are really missing the opportunity, and democratic countries are missing the opportunity to try to have these safeguards in all those countries outside the US. Another problem that we have, and just to be very concrete, is that, for instance, the criminalization section has some language about security researchers. For years, it's very similar to the Budapest Convention, but the problem is that since 2001 till now, the developments when it comes to cybersecurity and security research have improved a lot. And there have been many, many countries that have recognized the importance of good faith security researchers for disclosing vulnerability. And so the problem that we have is that the treaty just copy-paste Budapest, and that's not acknowledging any of the new developments. And that will harm security researchers because now this treaty has a clause, security researchers do work globally, and they can now be prosecuted by many countries at the same time, because there is one article on jurisdiction that you can prosecute, they can coordinate actions instead of prosecuting. If one country will prosecute the security researcher, it's just make the threat of being prosecuted at the same time in many countries higher than before. So it's two things. Doesn't recognize all the safeguards and protections to exempt cybersecurity researchers, good faith cybersecurity researchers from the criminalization section, and two, there increase a threat against them by many countries to be sued, be prosecuted at the same, investigated or prosecuted at the same time. Okay. That's just.
All right, thank you, Katitza. It's very helpful. Well, we have 7 minutes left before we go to open discussion, so I'm just going to conflate a couple of points that I wanted to pursue with you just real briefly. If I could get very concise responses, just to give people a sense of, which states are driving the process and how do we see this thing playing out once we move into the next phase of negotiations. Obviously, the Russians, Chinese, and so on, they've been very aggressive in putting forward a lot of very expansive kinds of demands. I've been puzzled by the role of the United States, European countries, other democratic countries in how they're playing this. I hear that the representation is from justice ministries and maybe getting a lot of law enforcement type thought into the thing, but it seems like that, as far as I can tell as an outsider who doesn't participate, like there isn't a lot of pushback going on. I may be wrong. So I want you to explain to me, how do you see the politics of this in terms of the coalitional dynamics and who's pushing what playing out, and where do we think we'll be at the end of the next 2-week process? If we could do that, just 2 minutes each, that'd be really great. Nick, go ahead.
Yeah, well, to answer both your questions quickly. So that has been a real problem, is that there are not enough countries putting a brake on some of the worst ideas, because they tell us two things. well, don't worry, we won't do these things. So your data is protected because we won't agree to this stuff, A. And B, these things all work normally now under Budapest. So there's no reason to believe that they will behave differently if we expand the number of countries who can live up to them. And we have, of course, all said to them, oh, no, you aren't able to protect everybody anymore. These provisions that you're allowing in would not allow you to say no. And why are you looking this through the lens only of how you would use these provisions, instead of asking yourself how the people at the opposite end of the spectrum of law would use them? And their answer is, well, countries are already able to do some of the abusive things that you are worried about. So since we can't stop them from doing it in this treaty, why try? Which is an astonishing thing for a country like the US and others to say, astonishing. And of course, our response is the UN should not bless behavior that we all agree is outrageous, abusive, and against international human rights norms. And there's silence by contrast. Or, well, this is a justice treaty and we're not supposed to be, we don't solve all problems in justice treaties. So it's really a breathtakingly bad combination of arguments.
That is absolutely astonishing. Tatiana?
Every word that Nick said is my experience as well, with some deviations in individual delegations. Some of the countries take really strong stand publicly as well. Canada has been the most vocal. It's probably like kind of last resort there, for anybody who believes in human rights. Other countries are soundly deviating, even if they support human rights, or silence, or keep silence on some of the issues. What really strikes me, I wrote it, and this is the same what Nick said. They say, oh, but we don't do these things, and they do it anyway. Yes, but you are legitimizing their practices. And somehow we think that we are democracy today and we will be democracy forever. Well, guys, you might not be. Any country can slide into authoritarianism in an Augenblick, as we say in Germany, right? In an eye blink, in a blink of an eye. But what I also want to say, I see astoundingly, and this is hopefully, this complements to what Nick said, the absence of ability to put things into perspective. As I said, it's beyond cybercrime. It's a criminal justice treaty that will set standards that are not easily to be undone. But if you look at the rule-based world order as it is right now, the successes of authoritarian countries in using the multilateral system to advance and legitimize their practices, this treaty will give them the best present, the best Christmas or whatever gift you can ever imagine. And this will erode, at the end, the rule-based world order as we know it. So the consequences is much broader than human rights, is much broader than criminal justice, is geopolitical and political and what have you consequences that somehow countries cannot see beyond their positions in these cybercrime negotiations. And this is what makes me really sad.
You guys are not making me feel more cheerful, but that's okay. Katitza, a final thought, and then I open it up. You're muted. Yeah.
I'm concerned. Hello? Yeah, I'm concerned with what things are going. I will say that it's not only Canada who have been a champion in human rights. I will say that also Uruguay have put forward a very good human rights language that was supported in the last session by more than 50 countries, but sadly was not included in the consensus document or the new version of the treaty. So that's like really sad. Obviously, Canada did an amazing speech. I agree with with Tatiana, I remember he saying, criticizing a leader, innocently dancing in social media, being born a certain way, or simply saying a single word, all far exceeds the definition of serious crimes in the States. These acts will all come under the scope of the UN treaty in the current draft. And after those speech, first time ever, everyone in the room clapped. And it was like a moment when, oh my God, there is someone defending human rights. So that's Canada, a language similar protecting LGBTQ+ was put forward with Uruguay, and sadly not included in the text. Just to finish, I have no more than say that I'm really concerned. The treaty is going to be concluded in just 1 week from now, and we need to start being more vocal about the outcome, and that treaty shouldn't be accepted if it's approved in the current form.
So we do think that after next 2 weeks, it will be approved. That will be the end of the process for the AHC, and it will go to the General Assembly in the fall. Is that correct? Any reason to believe otherwise? Yeah, Nick? No, there's no possibility that like wicked democratic countries will all walk out and refuse to sign, nothing like that.
We are
not that dramatic.
Sorry, we're now starting our audience participation part of the discussion. Let me just kind of make a brief comment, which is, as much as I wish that Katitza's position would be that of the United States government and that EFF would run the country, the fact is that we do also have other constituencies, and for example, the law enforcement community, the intelligence community, and I have not quite heard what their position on this matter is. Not that it must be overwhelming in terms of outcome, but it certainly would be important for us to understand that. So if you guys can kind of weave some answer to that question as you respond to other people's comments, that would be great. So Bill, would you take now people from the audience?
Just as a reminder for anybody that does want to ask a question, please use the raised hand function so that we can recognize you.
Please raise your hand. Please say who you are. And again, as I said in the chat, I hope some of the people who've been having a very good conversation there and raising a lot of issues will consider raising their hand and speaking now. We have a half hour. If you don't do that, I guess ultimately I'll swing back and try and read some of them, but it's much better if we could hear from you. So let's start. Okay, go ahead, Paloma. And please introduce yourself. Paloma.
Hi, thank you for this awesome discussion. My name is Paloma Lara Castro. I'm from Derechos Digitales. We are a Latin American NGO who have been participant of this process actively since the beginning, along with Katitza and others who are joining here. So one of our main concerns that adds up and complements the points that have already been raised by Katitza, Tatiana, and Nick has to do with the gender implications of the treaty. So we have been concerned over the issue of how this treaty is going to have implications on gender equality, specifically regarding criminalization. So just to summarize some of the things we've been talking about is that even though we appreciate and we celebrate the fact that gender mainstreaming has been included in the preamble, we consider that this is not sufficient to ensure that this treaty is not going to be used against people in the basis of their gender. And in relation to that, what we've been working on is a publication that actually Tatiana was participating as well in the revision committee. So thanks, Tatiana, for that amazing work you did. We did an investigation, and just to briefly tell you about it, with APC regarding how local cybercrime legislations are being used against people, minorities such as women and LGBTQI communities, with the use of the law to silence and stifle dissent, and how this has serious implications on gender equality, understanding that freedom of expression is a basic right to ensure for gender equality. So what we want to say with this investigation that aims to provide evidence-based facts to this discussion is that we're not talking about potential risks, but actual harms that are being done. So as Tatiana and Katitza mentioned, this treaty, if it's approved the way it is that is being framed, not only is going to legitimize these type of practices that are already very problematic, but it's going to set the standards for other countries to be able to do the same. So this is very problematic, and we're very concerned about these issues. And in the last negotiations, as Katitza mentioned, even though there are some countries like Uruguay that try to include gender as a protective human rights within the treaty, this was not approved. And actually the discussions and the positions of the countries are very concerning on this issue. There is no interest in including gender as a protective category or in considering how this is going to affect minorities. So I'm going to leave it at that, just not to go overboard, but I'm going to leave the investigation in the chat so you can access to it. And I'm also available if you want to talk more about these issues. So thank you.
Thank you. And that's very disturbing to know that there's been no uptake on those issues. I'm very puzzled. Alexander, please go ahead.
Hello, thank you very much. I'm Alexander Savlin from Free Moscow University. And I have another set of concerns that's for non-democratic countries, or for countries who are pretending to be democratic but kind of autocratic or becoming such. Discussions about how this country presents or works on such conventions are usually clouded or not publicized. So in Russia, we will know about this convention from official post of official media only if Russia will be successful in putting something of its ideas, like Tatiana told, into agenda. Otherwise, neither human rights protecting organizations nor academicians will even notice, well, except the ones who are working with government completely. So my concern not about this convention, and with it also, maybe such discussions like happening here should go a bit outside of academic world and, well, move somewhere broader. Especially, well, as being in Russia, I feel that people or researchers like William or like Tatiana tries to abstain for any communications with Russian entities, because Russia is very evil now, but it's really huge player in United Nations ground, using United Nations as its political war ground. So that's maybe for the further events like this, it should not be just informative, but try to invite more people from broader communities rather than, well, usual suspects on participants list from IG organizations or academics. Thanks.
Usual suspects. Okay. Responses to those two questions from the panelists, please. Anybody? Tatiana, why don't you go?
I will skip this pointing finger at me that, or at academic, that we don't communicate with Russian entities. We have a reason not to, or those of us who do not. That's firstly, and I'm not going to respond anything like this any further, if it appears. Now to the more general debate. I have been doing a lot to bring this debate beyond like academic and policy circles, and not only me. I think the intervention from Derechos Digitales, I think all the work Nick is doing, Katitza are doing, there is so much more going behind the surface that you see, because what you see is probably the ad hoc committee, a few blog posts and some letters, public letters sent about this convention. People are working at the background, raising awareness among stakeholders, among industry. And even if you look at these entire negotiations, it's unprecedented how many stakeholders took place, spoke against this, tried to promote human rights. And I would say, sadly, that if in some countries the communities are not mobilized, the civil society is not mobilized, we cannot mobilize everybody on this planet. But I'm sure that each of us who is involved in this negotiation is trying to spread the word, is trying to raise awareness, because we are all extremely, extremely, extremely alarmed. Thank you.
Thank you. Others would like to briefly respond to the first two questions. If not, then I will ask for next rounds of questions. I'm looking in the chat, and I've seen a lot of points being raised by Henriette, Nigel, Cheryl, Sally, Obiama, others. So would any of you like to raise your hand and speak your question? Yes, please, Obiama. And if I'm welcome, please say who you are and so on too. Go ahead, Obiama. We've got your hand frozen and just your picture. If you're... There we go. Okay, good. Yes, please. You're muted again.
Okay, good day, everyone. My name is Obiama. Work with Media Rights Agenda, a civil society organization in Nigeria. I think with respect to my question, I would like to know what the update is on the definition. Because for us as an organization, one of the fears that we we actually share on the convention is looking at the realities of most countries in Africa where cybercrimes are being used to silence dissenting voices and press freedom. We worry about the definitions that we have right now on the convention. And so I would like to know what the updates are on the definitions that we have right now in the conventions, because we fear that most times when we defend journalists and individuals who are being suppressed, who their right to freedom of expression are being suppressed by the laws in their countries, we worry that this convention actually now is something that the government will turn to say, if you are saying the international standard is this is what the convention is saying. So we worry about what the convention is actually backing up right now, because it leaves us with no international standards to run to when there's a convention that actually backs the government, suppressing the rights of freedom of expression. Thank you.
Thank you very much, Obiama. I saw Henriette Esterhuizen's hand briefly, and then I do not. I'm not sure what happened there. Henriette?
Well, my question was actually similar to Obiama's. There was a working group on definitions, and I think Mexico, South Africa were chairing that. And I was just interested in what progress they made and whether it was positive or negative from a human rights perspective. So the same question really is Obiama's, because even if this treaty is not accepted, I think, if there's agreement on language and on definitions that could then find its way into national documents, that's very worrying.
Okay, great. I'm looking in the chat. I see Ellie Noam had a comment about law enforcement and intelligence communities and their role. Ellie, do you want to weigh in on that?
That's what I asked earlier, which is where does the American, and for that matter, other countries' law enforcement communities come out on this one?
So, okay. I was understanding that Nick and others were saying that they were problematic, but Nick, go ahead.
The attitude is we can have all of these broad powers. The safeguards are enough because we will always say no to overbroad requests. Like I was saying, it's that's the attitude amongst way too many of the states, and then on the other side is you have a large group of states who don't have any history in cybercrime or international cooperation on regular crimes is also limited. So they're coming to this and they're looking to get some cooperation when they don't get it now. But because they don't have a history, they don't know what to ask for. And so they're foreign ministry people who actually agree in many cases with the issues that civil society and industry are telling them, are unable to get buy-in in their capitals because the people in the capital say, well, but maybe we might need some of these powers because well, let's have them because maybe we need them, and if we don't have them, then we're worse off. And so it's a terrible catch-22 situation, and the response of the U.S. and the EU and the UK and the others is all the same. Well, we just need to cooperate on cybercrime, and we're not going to allow any abuses to happen. I will say that in some cases it's worse than that. Like a certain G7 country, it's a long democratic tradition to use that term. I said to them, look, why don't you all stand for some time limits on any of this and some obligation that people are able to know their data has been handed over to a foreign government for law enforcement purposes when it's no longer necessary for a prosecution or investigation. He said, well, someday we might, I said, it's not legal now to do that in your country, and it hasn't been for centuries. All warrants have time limits. They can be extended, but a court order is required, et cetera. He's like, well, things might change someday. And I said, what do you mean things might change someday? You mean you're okay with asking for a power that would be unconstitutional because someday it might not be unconstitutional? They said, well, yeah, basically. So like if you have a G7 country whose interior ministry takes that kind of position, why would you, that's crazy. I don't know how else to put that. That's crazy. We're going to ask for unconstitutional powers because someday they might be constitutional.
I also want to jump here. So, Nick, one of the arguments that law enforcement says, or the United States or other countries said, is that, the treaty has some safeguards. It has dual criminality, and so they will say, yeah, but the dual criminality is actually, it's applied only optional and it's not mandatory. And this means that people could actually opt to not apply it and still collaborate in crimes that are not actually the same in the same country. That's one issue. Law enforcement will say, or the United States law enforcement will say, well, there are some grounds of refusal, but even the provision on grounds of refusal is very narrow. I don't know even if the political offenses get into the text or not, Nick, remind me that, but at least we wanted the grounds for refusal to cooperate, to refuse assistance on investigations on human rights grounds, a little more broader than just political offenses. But even that, that's their argument. We have that. We can refuse assistance based on these grounds of refusal, which is very narrow. Not even human rights violations, it's a grounds of refusal. But in our opinion, leaving such critical decisions up to the discretion of the government authorities is really, really problematic. The treaty opens the gate for international cooperation for every conceivable offense. Those authorities are going to need to become experts in every crime around the world and their potential misuses. This isn't focused anymore. Rather than try to focus on cybercrime and be an expert to be able to refuse, now they will need to know all these requests. It's supposed that this treaty was expedite that request. Now, investigation of any offense, they will have to be experts. Every offense, they will have to respond to the request, and to be able to refuse a data request, it will be super hard because they will need to have a lot of knowledge to do that. Okay. And so it's just making complicated. Yeah.
Thanks. Tatiana, I see your hand. I do want to try and get a couple more of the questions in. So if you could try and make it concise, we've only got 10 minutes left, and there were like 4 questions in the chat, and I see another person with their hand up. Go ahead.
No, I just want to answer Andrea's question about definition. She kept asking it on the chat and online. Right. So basically, Andrea, I don't think that the definition, the work on definition will solve the problem of broad criminalizations or criminalization of speech, because the work that South Africa was leading on definitions is about defined computer system or information and telecommunication system or subscriber data or traffic data or whatever. So basically, these are very technical definitions for the purpose of the convention. They do bear some meaning. I think Nick said at the beginning that Russia was arguing for very broad scope, like even a phone and text on the phone, like used in crime, and this is the ICT instead of computer. But this does not really have anything to do with criminalizing of speech. So to me, there are separate issues. The definitions are very important, but the consequences are very different. They will not solve the problem of broad criminalization.
Thanks. Rory Sang, I see your hand, but let me take a couple of questions that have been on the chat for a long time first, and then I'll come back to you. So Nigel Hickson for the UK government said, this is all very worrying. I assume the EU folks would not sign up to a treaty that undermines the general data protection regulations That's an interesting question. And then Sally Wentworth from the Internet Society says, I have a similar question. I've heard that Canada is vocally opposed and the EU is silent. What about other democratic countries? What is their posture? We talked a little bit about the US. Any other views on Canada and Europe that have not already been touched on by any of the speakers? Any quick reply? Yes, Tatiana.
Yeah, I just want to second what Katitza said. Uruguay and some other Latin American countries remind me, Costa Rica, I think Dominican Republic and some others were super vocal, and their proposals sometimes were, I'm sorry, I'm actually delighted, much better and much more, much stronger than what European Union is proposing. And I think that these efforts should be appreciated. And Katitza, I mentioned Uruguay many times in other contexts. I don't know why I forgot them here. So I would urge us not to think like Canada and EU and America versus everybody else. No. There are many more countries standing up for human rights and global rule-based world order.
Mm-hmm.
Yeah, and one answer just to the GDPR question, I said it won't undermine the GDPR because the treaty defers to national law. And if the EU has the GDPR, then the GDPR will apply accordingly. The same and with the probable cause standard in the United States when it comes to interception of communication. Okay. The problem is the cooperation with other countries, It's like, okay, I'm a democratic country, I'm protected. I don't care about the rest of the world. The rest of the world will come, don't have any protections. Yeah.
Right, exactly. Well, the U.S. doesn't exactly have powerful privacy protection laws. Rory Sang, go ahead, please. You've waited. Please say who you are.
Thank you, Bill. I think Tatiana has covered a bit, in fact, holistically on the technical definitions and how they need to be defined, this being a technical treaty. What I think the media or the journalist community is concerned about, as Henriette said in the comments, that criminalization of freedom of expression goes against state or constitutional obligations of the state. But what I think poses a major problem is that we need to have a very deep line of demarcation between ICT definitions within the treaty and definitions of distribution of false information as may appear in domestic legislation. I think that if we take dissemination of false information as it is under the treaty, which is using ICT devices or computers to produce or disseminate misinformation or disinformation, that needs to be taken differently from how producing false information may appear in local or national legislation under receipt or dissemination of information, for instance. I don't know if I'm making sense, but what I noticed is that the media has tried so hard to merge or rather force their definitions to fit under the treaty, which is not necessarily a bad thing, but we need to know that these two things are not necessarily divorceable, but they're not necessarily meaning that we are now saying there's no freedom of expression under the treaty, because even national legislation, dissemination or disinformation is illegal. We're only just elevating it at treaty level. There really isn't no two ways about it. Thank you.
Thank you. Rory Sang, you didn't say where you are. Where are you joining us from?
Sorry, I am from Lesotho, joining from South Africa.
Fantastic, thank you. Jose, did you put your hand down? You had your hand down?
What happened is I'm running out of battery, so I'm going to connect.
Okay.
So hold on, I'll raise it again.
Let me just read, we're going to move towards closing in a second anyway. And if you get it together quickly, then we can do something. I just want to read two more comments from the discussion. Cheryl Langdon-Orr from Australia said, unintended consequences result from less rigorous processes, and I suspect many unintended consequences will come from this. Vidoria from the United States said, in fact, we are seeing the transformation from democratic, for some definition of democratic, towards authoritarian all around us all the time. which is kind of a cheery view on things. Jose, do you want to get a quick last comment in, or shall I wrap up?
Yes, please. I have a question.
Please say who you are, where you are.
Yes, I'm Jose Lopez Alonso. I'm a criminal defense attorney from Mexico City. I also a lecturer of university, and we don't have in Mexico yet a cybercrime law. We are developing it. But my question is as follows: given these enormous challenges that imposes coincide all these sensitivities between countries with different human rights protection backgrounds, and given that in most all the international extradition treaties and cooperation international treaties between countries, they already have dealt with these sensitive issues of dual criminality, exceptions to cooperation, exceptions to extradition, etc. Wouldn't it be more easy to amend each extradition treaty that exists with specific countries and deal with these issues country by country instead of worldwide?
Okay, interesting last point. Nick, go ahead, and then we'll wrap up.
In fact, it's a great point. And in fact, it has been pointed out that UNTOC, the Transboundary Organized Crime Convention, already allows for e-evidence sharing. So it's actually not necessary to include e-evidence provisions in this convention at all. And moreover, that and the Anti-Corruption Convention also contain extradition, handling of witnesses, and all these other provisions that also this convention doesn't need and shouldn't have, because what's happened is they're being copied over and then weakened. Like the protection of witnesses article is a perfect example where we started with UNTOC, and now it's optional and left to each member state to decide whether or not it protects witnesses. So yes, it would be much better off if people relied on the conventions that already existed. But that just tells you we're not really in the same business here.
At the end of the day, growing out the Budapest Convention seems like it would have been a pretty good option, but a lot of countries just felt like we weren't party to designing the Budapest Convention, and we didn't get to express our political preferences through the negotiations, and so we want a new one. And so here we are. But I don't know what happens. Legally, I don't know what happens when you have two different multilateral frameworks that address a lot of the same questions. The signatories to the Budapest Convention might find, and tell me if I'm wrong, might find that they have obligations under Budapest that are not entirely compatible with the obligations under something new that comes out of the UN. Is that not possible? And if that so, then what happens?
Yeah, I believe lex specialis overrides lex generalis, and the
English, Nick, that means
that means like a specialized convention will override provisions that exist in a general agreement, like the Transboundary Organized Crime Convention. So unfortunately, the weaker provisions on, for example, witness protection would apply in this convention instead of the better protections that are in the Transboundary Organized Crime Convention.
Interesting. Okay, Tatiana.
I believe that.
Yeah, I just wanted to say, I agree with Nick that special, and we have a lot of overlapping provisions. Some countries have mutual legal assistance treaty, which is more specialized, and then they will use it and not Budapest and not something general. I just want to say that we can talk for a long time what would be better, kind of how to fix mutual legal assistance and update other conventions and use them, and we don't need anything new. I don't think that this convention was ever meant to really fix the issue of cybercrime or electronic evidence by those who proposed it. The goal is much broader than that.
It sounds like the goal is collection about everything else.
The goal is collection of data and many other issues, and nobody actually cares if there is UNTOC, UNCAC, and whatever.
And this is why I don't understand what the industrialized countries are doing. But okay, we have to stop. I want to thank everybody for participating. I want to thank in particular, as I always do, Jason Buckwhite, the Executive Director of CITI, for making this happen. And I turn it over to Ellie Noam for a final thought.
Well, thank you very much, Bill. Thank you very much, panelists and audience. This was really interesting, really important, really timely. My last thought is it does not sound, at least from the tenor of what I've heard here today, that the industrialized countries are really going to be supportive of this treaty. And so therefore, if the United States Senate or others would not ratify, then what actually will there be meaningful out there if enough countries don't go along with this particular treaty? So which gets back to the questions of more specific treaties or just leaving things as they are, or bilateral type agreements rather than this kind of sweeping global covering everything type approach that this treaty represents. And I'm not sure if I listen to this that there's anything that is ready for prime time, so to speak here. This is more like in the nature of a discussion rather than the nature of refining an existing document that is ready and has broad international consensus and within countries consensus. So thank you very much, everybody. And we will, yes, Bill, go ahead.
No, it's just waving goodbye.
You're raising your hand, which I took as the international symbol for I want to talk. But Bill, thank you very much, everybody, and we'll see you again. Goodbye.
Bye-bye, everybody.